there?
Yes.
Next
In
one.
case your lordship condone the delay subject to payment of 1 lakh, that is also already reported.
That will consider.
That receipt.
My lord, namaskar.
On merits,
Item number 2.
On the pay, the senior is in dispute. This matter which.
office कोटा देखी देगा 1 lakh rupees they have already.
In this matter,
Which matter?
in item 2, Miller,
Item 2.
it is appearing keys on his legs, Miller, and make pay for one partial.
On his legs or on his feet?
Let's
Legs, not feet.
Well, let me start my lord, then my lord.
one parcel.
Let me start. This is on priority basis and out of turn it was listed on mention and I am ready and I want to start the new argument for your lordship.
He is on his legs in other court.
Pass over. How much? 15 minutes? Just wait for 15 minutes, but.
Item number 3.
Item number 3, my lord. Justice had the matter yesterday. That is relates to.
Oh, yes.
Yes. For setting up the first, the grants of the petitioner matter, the cause of action still survive. You have to make some kind of grants.
But it is premature. They have taken a plea. The recommendation does not mean a final decision.
Why I am saying the cause of action still survive?
What is them? Report reform, the recommendation.
Before this election.
We can't issue a mandamus to take a decision within a time frame. I understand what you are doing. We can't issue a mandamus.
Only I pray minute dispose of this report.
I understand, sir. That is what I am saying.
Pursuant to the report.
Can I issue a mandamus in this form?
No. Why?
The law is against.
Because the report, what they have stated, my lord, I am just facing my lord.
Maybe against you, but ultimately they may discard. It is within them.
Okay, and your lordship has already earlier directed to give a reason order and give it to the petitioner, mentioning what is the reason they have rejected. That also not been there.
But they have not taken a decision as yet. So
Decision pursuant to the report.
again the same thing. No, sir. It's very difficult.
And then permitted to withdraw, my lord.
Or we can dismiss it as premature liberty in the event the occasion so arises. That is what is the only thing. The instant petition.
The earlier the petitioner held one case where the honorable civil stated that this is the matter of PI.
This is what they wanted, that it is a large village. There is already. To withdraw or last time, or we decide the matter?
The better petition. No,
Better to be dismissed.
no.
So,
This is the second round litigation.
sir, I understood the way you have drafted last time, yesterday also, my brother, the Chief Justice designate indicated to you what would be there.
With you. This one.
Yes. This is.
But item 5. First case, WPC 4 of 2025, we have already filed the counter affidavit. We have soft copy on others, and that would that counter affidavit would cover the third item.
Third item or whole of the item?
Third item and whole of the item to the extent the amendments are under challenge. But so far as the principal provision is concerned, principal provision, we have received these counter affidavit. Yesterday we have received the PWC. Lordship may grant us 2 days time, we will file.
In fact, today the matter is only to consider interim application.
Mr. Dalai, want to segregate?
No,
Want to segregate and decide two matters first when they have filed the counter?
it can be segregated. By of their own admission, it can be segregated. But when they have admitted in their counter that it is yet to be implemented.
So additional grounds which you have taken in other two cases.
No.
He wants to file additional affidavit on that.
No. He's not saying that, Lordship. He's saying, no. He's saying
He has
Lordship.
received Faraway's comment in
No.
other two.
No. He's saying, Lordship, there are two sets of writ applications. One is the original rules under challenge, and second is a subsequent amendment. He's saying, Lordship, he has filed counter affidavit so far as amendment is concerned. So the original is concerned, he'll file a counter, Lordship. So let him file counter so the original is concerned. The second application, which has already been filed a counter, that can be decided so far the interim application is concerned. Their own admission is saying it is not done.
Just
Lordship.
let me recapitulate the facts, sir.
Sorry, Lordship.
I'm taking up this 27234.
Lordship.
What I find is that you are challenging or assailing the amended rule 16.1. Now, by this rule 16.1 at page 57, I am looking at that the financial power has been enhanced. And it says that payment order shall be signed by the block development officer where the amount does not exceed 2 lakhs.
Yes.
And by block development officer and chairman of the committee if the amount exceeds 2 lakhs.
This 10 lakhs.
Now it is 10 lakhs, Lordship.
There are two issues, my lord.
I am looking, that's why I indicated the page number.
Lordship. 57 is the original.
Correct. Now, where is the amended problem?
Amended annexure 1, Lordship.
This is a notification.
Notification, Lordship. So the first page 50, Lordship, that is 2. So Odisha Panchayat Samiti according to
Yes.
Sorry, Lordship.
Section 19.
No, 57 is the rule making part. Just 1 minute.
14 days it says.
No, just 1 minute. So according to you, subsection 3 has not been followed.
One of the arguments. That is one of the arguments so far the procedure is concerned. But
No, that I find a notification is by an order of the governor.
There's an admission, your lordship, kindly come to.
Whether it was laid in the legislative assembly.
Page 10 of the counter affidavit, they have admitted.
Still pending. Your lordship may
There-
clearly see.
So it has not come into force.
Lordship, yes.
So this writ petition becomes premature.
Absolutely.
Your lordship. Page
What
10
is
of the
what?
counter-
Let us forget about everything. What do you have to say? This has not been placed in the legislative assembly. It has not taken a shape
Grateful.
nor has come into effect.
Grateful, Lordship.
No difficulty.
Grateful.
So far as this amended portion, this writ petition, that cannot be maintained at all
Lordship, grateful.
at this stage.
That has to be clarified, Lordship. You can Lordship kindly.
Whatever, we will accept that
Lordship.
because it has not been placed, so it has not taken a shape.
That's what I'm saying.
That- Now,
That will
so far as the parent section 16(1) is concerned,
counter. That they will file counter. They are saying they will file counter.
what they will say, what they will do?
They will file counter, Lordship, so
Achha.
far the parent act is concerned, Lordship. Parent rules is concerned. we cannot tell.
There's a second matter.
So far as the first matter is concerned, so far as notification which is under challenge, I think it is premature. It is absolutely premature. We will accept their contention
Lordship,
that it has not been laid in the legislative assembly, so it has not partake the character of a law
grateful.
as of now.
Grateful. That has to be clarified.
They have admitted.
But original will
Yes,
remain.
original will remain.
That will remain.
Oh.
That will remain.
Yes, ready the counter. We'll file the counter. or-
What counter? Original, what is the ground for challenge? Let us understand. It's a pure question of law.
Law.
That's why I'm asking, what is the ground for challenge of the original?
Enter contention of the petitioner's lordship, because they're repeating all the elected bodies of the state lordship. They're relying upon only one provision, that Article 243G and H lordship.
Yes.
And the entire contention is contrary to the lordship, the constitutional provision. And by virtue of this notification, these lordship rules, they have lordship curtailed the entire power of the self-governance system. And the bureaucratic interference has been introduced, lordship.
Not bureaucratic, it is an executive interference.
Lordship, kindly see the statutory provisions, Lordship. Lordship, kindly see what is the statutes are very clear. Our humble submission before Lordship, because the Article 243 is enabling provision, Lordship. So they have enabled law, they have come up with law. They have come up with statute, Lordship, statute, giving ample power, enough power to the elected bodies. And Lordship, kindly see, please come to Lordship for section 15 and 16 of the Act, Lordship. Section 16 of the Act. 15 says, Lordship, 15A, Lordship, kindly see, Lordship, 15A. Lordship, 15A, Lordship, capital A. It's magic.
No, I have read it.
Then Lordship,
Is a power of nomination by the government and the functions of the block development officer.
Then Lordship, kindly come to 16, Lordship. 16. They are saying, Lordship, constitution of the Panchayat Samiti. It includes, Lordship, entire elected body, 3-tier Panchayat election, Lordship, all Panchayats and Samitis, and Lordship, it includes, Lordship, Panchayat Samiti. 16, Lordship.
Yes.
Then Lordship, can come to section 18 for a moment, Lordship.
True, but the
Then-
Revenue Divisional Commissioner and the collector also have been robbed in the meeting.
Then 19. I'm coming one by one. 19 is very important, Lordship. Then 19 is Lordship Pence. The chairman of this.
No, I understood.
Lordship. Lordship.
What?
And
This is his amendment of 1961.
Lordship.
So it says that the chairman will ensure that it is all the decisions is implemented through the executive officer,
Executive.
who is a block development officer. Yes.
20 Lordship, kindly say they have the powers and process. Submittees are subject to such.
No, I understand. Yes, planning, execution and supervision.
Lordship. Execution and supervision. Then Lordship, can you come to section 2? 20 a capital A, Lordship.
Yes, 20.
20 a capital A, Lordship.
Inspect and supervise all the convene and conduct the meeting and supervise, nothing more than
Lordship,
that.
giving Lordship overall idea, Lordship, how they have enacted by law. Then Lordship, can you come to 28? They have defined what is Panchayat Fund, Panchayat Samiti Fund.
Yes, so power is given to the block development officer to be a custodian of the entire Panchayat Samiti fund.
That is the law, Lordship. He should be custodian. So we are not on that, Lordship. When Lordship bypasses, Lordship bypassing the bids without knowledge of the chairman, that is the Lordship crux of the matter. Here, Lordship.
No, there are two aspects. As I find in subsection 2 also,
Lordship.
that he may be in the control of the government, whatever,
Lordship.
block development officer, he is simply act on the basis of the decision taken by the Samiti.
Grateful, Lordship. That is our entire contention, before Lordship.
So Samiti, if he says that this payment has to be released, then he has no other option.
Yes.
Subject to the control of the government, that is always there. He has to implement.
So here, Lordship, what by of this amendment, what they have done, Lordship, they have given the entire, let's say, discretionary power, Lordship, to the
No, that is not. 16(1) is a. By rules.
by rules, Lordship. By rules, Lordship. And this rules is contained with the statute, Lordship. Apart from the, again, contained with the
Just one
constitution,
minute.
it
Just
is
one.
contained with their own act, that's it. But the,
Where is original rules?
original rules, Lordship, that is, Panchayat Samiti, Lordship. Accounting procedure rules. No, accounting procedure rules is 2002. Lordship, original rules, Lordship, that is 1973. 1969, Lordship, Panchayat Samiti.
No, this book does not contain, that's why I'm asking.
69.
Election rules are there, CSC is there, rules, then qualification,
Lordship, these rules is under, Lordship, I can.
condition of business.
Lordship, here Panchayat Samiti accounting procedure rules 2002.
Budget rules, no.
No, Lordship, this is Panchayat Samiti accounting procedure rules 2002. This come up the Lordship.
Local law को volume.
Local
Local law को volume.
try boil nahi, Lordship. I can. Nahi boil.
Few publications don't have it. I think these publications don't have it. Only one or two publications which have it.
Local law publication.
I have personally, I had given the booklet.
Local laws perhaps legal experience publishing one book that's having.
Second number volume.
Volume 14.
Local law achievement.
Oh, I got it.
Yes.
Yes. Mr. Kirach.
Because he is a control.
It's
Judgments, Lordship, the number of judgments, Lordship.
number of judgments.
No, Lordship.
Give us at least one or two.
Lordship, we will argue on the point that this rules is contra the statute, then Lordship.
There cannot be any doubt about it,
Lordship.
that the rule is subservient to a parent act.
Lordship.
If there is any inconsistency or repugnancy between the parent act and the rules, then in that event, the parent act will prevail and the rules will be declared as ultra vires. It is a subordinate legislation, no doubt about it. There cannot be any doubt. And the power is emanating through a parent act.
Lordship.
There's a rule making power under section 57. That is what's there.
Lordship.
So it has got no independent status in that regard.
Lordship.
We are conscious you give. First thing is that so far as the autonomy is concerned and the control of the government is concerned, how you can reconcile, because in order to find out whether any provision is ultra vires either to the Constitution or to a parent act, then in that event, the first and foremost duty of the court to harmonize both the provisions so that it will be made workable. Now, harmonizing, one has to understand that how to harmonize. And if it is impossible to harmonize, then it will be declared as ultra vires.
Yes.
Now, if you come to section 28
28 question.
of the Act,
Yes.
you're talking about the Panchayati Fund,
Funds.
Samiti Fund.
Committee funds.
Okay, Panchayati Samiti Fund. So it says that it will be given by the government,
Yes. Sir.
which will partake a character of a Panchayat Samiti Fund.
Fund.
And it will be applied in accordance with the one very interesting point is subsection 1, because this fund will vest into the Samiti.
Yes. Sir.
And the vesting is paramount and is sacrosanct. It cannot be divested otherwise by virtue of a legislative fiat. Once vested, cannot be divested unless there is a legislative exercise is done. So in that event, I am just talking in your favor. Don't worry, Mr. Doloi. Just to understand more clarity, just to bring more clarity.
Yes.
Subsection 2 is another aspect which one should not overlook. It says that yes, block development officer is there. He has a power because he will be in charge of the entire Panchayat Samiti Fund. And only thing is that he will follow all the rules as may be prescribed, and will also implement the decision of the Samiti.
Samiti.
Suppose if a Samiti has taken a decision to disburse the amount, then according to him, if it is within the prescribed rules, then he has no other option but to implement the decision of the Samiti. No doubt. But one line, subject to the control of the government, because it is after all a government fund which is provided to a panchayat. If the government retains a control, then in that event, can you say that an independent exercise of verification, satisfaction is contrary to the rules? Because 16(1) says verification and satisfaction, both of the block development officer.
That's the same situation.
That means an independent decision he will take, irrespective of what the Samiti has taken a decision, irrespective. And where you find that the power of the autonomy of the Samiti is taken away because it is a block development officer who will take the entire decision, independent decision. He may refuse, he may allow. It is all up to him. I understood. That's your argument. So how to reconcile with this subject to the control of the government?
That's the same situation.
Chairman is retained.
No, that is above the value.
Above the value. So that is the cap.
That's the same
No,
situation.
but again, the enabling provision is verification
Oh.
and satisfaction of the block development officer is important.
For that total.
So in total. Second aspect, Mr. Doloi, is it not merely a ministerial exercise? Because he has to just collate the documents, saying that whether it is in conformity with the particular norms, or in terms of any work order or the tender having floated.
In fact, rules versus something.
That is what, no, I'm just thinking of giving a harmonious interpretation to the word. These two words are used. Who shall verify the same, and if satisfied such will and order, he will sign it. So two part. One is the verification part. Verification means he will just tally that everything is in order. And satisfaction that after all he is entitled. So this is merely a ministerial exercise, really not.
Can I just assist?
After the decision of the Samiti.
Can I just assist your lordship?
Let's say, validity after decision submit, we don't have any other.
Or one has to harmonize. I'm just thinking in that line, sir.
Let's-
Can an interpretation be not perceived that yes, according to 28(2), he has to implement the decision of the Samiti. But while implementing, he will also check in, verify, and will also satisfy himself that these bills are all in order. He may refer it to the Samiti if there is any discrepancy found in the payment or the bills or something is submitted. I'm just thinking in that line, just to harmonize.
Not your lordship's mind, can I just assist your lordship?
Contradictory, you know, still further contradictory 16(2).
Let us read it, this subsection 2 of 28. I'm so sorry.
I'm sorry.
He is referring to me.
I'm so
I
sorry.
understood.
I'm so sorry.
He is referring to, I was just concentrating on sub-rule 1. I was concentrating on sub-rule 1. Now he has drawn my attention to sub-rule 2 as well.
I'm on 2 words, unnecessarily delayed.
The
This is a difficulty. Power to sign and the power to take a decision on a financial aspect are two different aspects. The autonomy to take a decision on a financial aspect is still retained by the Samiti.
yes.
It's only the disbursement of the money by using a particular authority to sign a negotiable instrument. Does it mean that there is any independent decision? It's a signing of a negotiable instrument, nothing more than that. And it says, sub-rule 2 says that if the chairman or whatever, the chairman, if he's not signing, because there are 2 dual powers which is given. Let us go with the original. Up to 2 lakhs of rupees, the unilateral power of the block development officer to sign. Above 2 lakhs, it should be jointly signed by the block development officer and the chairman.
Yes.
Sub-rule 2 says that if the chairman delays,
Yes.
then in that event, it can be signed by somebody else. It is really a disbursement of money. It is merely a signing of a negotiable instrument, nothing more than that. It should be according to the decision of the Samiti. Again, I'm thinking, just to make it workable.
You are to harmonize, as your lordship says.
That is what I'm saying.
That is what your lordship suggesting, to harmonize the.
Correct. Unnecessarily throwing out something out of the from the statute. You know, that is the canon of interpretation. The first endeavor should be to uphold.
Your lordship mean that even if he signs the check, that signing should be in terms of the decision of the Samiti.
That is 28(2). I am just thinking of the parent act.
That is what exactly 28(2).
That's true.
Only when the Samiti decides that this.
That's why I say,
Yes.
and then this part is merely a ministerial aspect. Who will sign the instrument? I'm just thinking.
Has to be like the video.
But lordship, kindly read Rule 1991 of the rules. Rule 19 and 91 of the Orissa Panchayat Samiti accounting period are 2.
19 and 19(1).
90 and 91.
Oh, such a big rule.
Rules. This is because we are, let's say,
You have gone beyond the statute, beyond the sections. Sections does not have so much. Yes, 90.
90 and 91. Rules. 91 is very important. Lordship, 91.
No, I understand. I understand. I understand.
The third person, but it's unfettered lordship power to the block development official. Had it been there, then also we have to not have any grievance lordship. Can I assist your lordship on this point? 90.
Let me first frame my mind. How to make it workable.
90.
I understand what he is aiming at.
Taking a cue from that, I just have something in mind, just to assist your lordships. 90 says the chairman of a committee may stop any payment by the block development officer for.
That may be a reason why I'm thinking aloud. I'm thinking aloud that the Samiti, I'm just,
Malas.
wait. I understand that you are heading when the Samiti has already taken a decision. Then it has to be implemented, and this provision that becomes some kind of an overreach. I'm on a different. Can we not harmonize it? Yes, the Samiti has already taken a decision, and then it is supposed to be disbursed. Subsequently, the chairman may found that there are certain things which requires to be reconsidered, and therefore may instruct not to release the money. And the reason is that the next sentence, the last sentence, he will thereafter place the entire matter to the Samiti, that is for review or a redecision or revisitation of the matter. So the power of the chairman to instruct not to release the payment, but that is also subject. And this, again, I'm saying the communication or a resolution may be communicated through a particular official, which may be a chairman, which may be a vice chairman or whatever. So it is really a decision of the Samiti which is paramount.
No, the way I have understood it is to assist your lordship in this manner. Samiti takes a decision that this is the work which is to be done, and you have to make the payment. If these criteria are satisfied, you make the payment. So thereafter, the BDO comes into picture. He inspects and verifies and inspects the bid is in order, and he orders the payment, recommends for payment, and he signs also the payment. Thereafter, the movement of the file has to be placed before the chairman, who will then decide, who will apply his mind independently in terms of 90. The chairman of a Samiti may stop any payment by the block development officer for reasons to be recorded in writing and place the matter before the Samiti or the standing committee concerned. Now, the file having gone to him, now if the payment is done at the level of the BDO and it goes straight away, the fund is released, then there will be no occasion for the file to go to him. And there will be no occasion for any stoppage of payment thereafter.
Can it not be said so far as the latter part of it is? Because it is now, now it is now divided on a pecuniary basis. One is below 2 lakhs of rupees, the independent authority of the BDO is reserved. Chairman does not have anything to play. But if it goes beyond 2, then the chairman's role will also come in that regard.
This is 90 encompasses everything.
Understood.
90 is not.
I'm just thinking there should be a logical, I would say the realities. Which one? Because these 2 lakhs rupees is too small an amount in the today's scenario, where the very small, the persons who are really working for a very meager or a small amount of the work, at least if they do not get a timely payment, they will not be able to sustain. So that's why he says that if it goes to the Samiti, if it goes to the others, how can they survive? It is a more, I would say, the rational policy decision in this regard. And anything which goes beyond, where the very, very good player or the financially sound players are there, if they come, at least the conscious decision or inclusive or collective decision of both the Samiti and the BDO and the government is also required to be taken. That is required to be taken. For that reason, it says that the small amount, whatever we're talking about, why it will go everything through the chairman.
The act started with 25,000, if your lordship appreciates. The act
Sir, in the today's scenario, the inflation has increased. The inflation has increased. 2 lakhs rupees can be visualized in a today's scenario, sir. We are in 2026 now. Understand?
That is right, my lord. But here, my lord, section 90
Section 90 is expensive. Section 90 does not play any such roles.
I understand, sir. That's why I'm saying that if sometimes it so happened, then one has to harmonize that even for a smaller amount. Suppose a particular person has been awarded a contract. I'm just hypothecation, just to understand. Don't take it a final opinion. It is really, I'm still in the stage of understanding the things. Suppose a hypothetical case. A contract is given to a very small, the organization or the firm or an individual to clean a water tank in a village. And it costs 50,000 rupees for cleaning. Just imagine. And then he does it. Now, how much he earns? Just imagine. How much he earns after spending some amount on the raw material or something. Now, if this particular payment is held up and subject to the decision of the Samiti, kindly look at the plight of those small persons who are doing those services. For that reason, it says that it is an autonomy of the block development officer. If he finds bills are in order, satisfied, everything will go, no difficulty. It so happened that somebody must be there to monitor, supervise the entire execution of the work, and will definitely issue some satisfactory report or a certificate that it has been done as per the requirement. That is only the satisfaction part. Now it happens that subsequently it was found that something has happened because of this cleaning. Say it has not been done, but the certificate is issued wrongly. Then the chairman under Rule 90 can definitely instruct the BDO, stop the payment. I'm going to the Samiti because this is what we wanted, it has not been done. That extraordinary power is always retained just to ensure not only that the work is executed to the fullest of satisfaction, but also as per the requirement.
This is in tandem, my lords, with the purpose for which he has been elected.
Absolutely.
He comes to the
It has to be.
people.
It has to be.
So therefore, the accountability also ultimately.
But if every fringe amount or every fringe things is again placed before the chairman or the Samiti, can't you visualize, because the Samiti consists of large number of the elected members. And it is not possible to have the meeting of the Samiti on each day.
Possibly, my lords.
Not be. So one has to wait for a longer period.
That's a very rational view, my lord. They're extremely rational view. But the statute was not worded like that.
But one has to give a meaning to that. That's the way the courts are.
So therefore, my lords, what I was suggesting to your lordship is that once a person has been elected, some amount of trust also has to be based.
True, no doubt about it.
It cannot be inferred that for every bill that goes, he'll put an objection.
Sir, the difficulty is I'm saying that you have to dissect. Autonomy for the management, development, taking a policy, implementing a policy is with the Samiti, which is absolutely in tune with the constitutional provision when the Panchayati Raj system has been accepted and included into the constitution. That is what is there. Only thing is, again, I'm saying, Mr. Roth was there. Only so far as the disbursement of the money is concerned, autonomy has to be respected to take a decision whether the payment has to be made or not to be made. Once the decision is taken by the Samiti itself that the payment has to be made, who will sign the instrument? Who will do what? If it is given to the block development officer, where is a invasion of that particular constitutional right? I'm just thinking in that light.
To that, but formally also the file has to go before the chairman. Otherwise, how does this power get worked out? 90.
If we try to clarify that position,
Link to
Sir, once the Samiti has taken a decision, say Samiti has taken a decision to construct a 1 kilometer road within the village. It is within their power to take a decision.
The bill is.
then the Samiti is within its competence to issue or take whatever decision to select the vendor to contractor or whatever is still retained with the panchayat.
Yeah.
Now, only that's why I'm saying that once so far as the execution of the work is concerned, it is also monitored by the panchayat.
90 is linked directly when it relates back to 21 of that.
Only, sir, the
Okay.
grievance is that who will sign the instrument?
My submission was different. My submission was the power under 90 can be traced to section 21A. The sweeping powers of planning, execution, supervision. So that is how Manas 90 has some logical base.
But every file, as you suggest, has to go to the Samiti. I do not agree in this regard.
Otherwise, Manas 90.
No, sir. That I do not believe that will really make the entire
It may not
functioning. It should be an efficient one.
Why I was saying so, Manas, but it may appear to be a little tedious, but such a clarification is inbuilt in the rules. Otherwise,
Sir,
90 itself-
section you are not challenging where the block development officer is an executive officer who is the entire fund.
he is to-
He is a custodian of the entire fund.
He is actually, my lord,
So-
if your lordship looks at it, he is like a chief operating officer, COO, not even a CEO, even though the language is executive. He is actually a chief operating officer. If your lordship looks at the scheme of the act as very ably put forward by my friend Mr. Dale, he very ably and adroitly put forward everything and more eloquently by Mr. Rathod.
No, I don't.
If your lordship sees, my lord,
One has to
appreciates
understand.
that part. So therefore, he is only like a operating officer. Possibly his word cannot be the last
The
word
draft has been
on payment. The last word on payment has to rest with the selected representative. Otherwise, then the whole
No,
process would have
it has
to
not
go.
been finalized. It has not been laid on the assembly.
Sir.
No, it is a notification they have taken up.
Just cite rule 91 and rule 4 of that very same. Kindly, sir.
Yes.
Rule 4 and rule 91. These two rules your lordship will see and your lordship will, I think,
It's a pure question of law. What is?
kindly see rule 4 of that accounting procedure.
Don't get misled or by something which
No,
we
yes,
observe.
it's a
It's
discussion.
all in pursuit of understanding. It is not a final opinion.
No, right.
Well,
Kindly see rule 4 of that same rules, 2002 rules.
Yes.
Payment of any sum out of the fund may be made by the block. I'm sorry.
yes.
Rule 4,
Accountancy procedure.
accounting procedure rules.
I do not know.
Rule 4, your
Sorry. Sorry, sir. Yes. No.
Local.
Yes.
kindly see. Payment of any sum out of the fund may be made by the block development officer, subject to prior approval of the chairman in absence of budget provision in case of. There is an exception. In all these rest of the cases, this can be made if there is no budgetary provision. But in case of a budgetary provision, payment of any sum out of fund made by the block developer officer, subject to prior approval of the chairman. But you will get one catch here, subject to prior approval of the chairman, which are in the budget. Now, kindly see rule 91.
Which are beyond the budget,
That's what I'm saying, beyond the budget.
not within the budget.
No, beyond the
Or
budget,
in the budget.
beyond the budget. That's what
Beyond
I'm
the
saying.
budget, that something is there which include the repayment of money.
Right.
Belonging to the contractors, the executive,
Yes,
or either the person.
Yes.
In deposit or money collected or credited.
right,
whatever.
right.
So what it says is that anything which goes beyond the budget. Budgetary allocation.
Allocation,
Budgetary allocation, or in a very,
that is annual action plan.
in a very conservative way, as Mr. Dawai always predicts. If it is beyond the Panchayat Samiti fund,
Exactly, an annual action
then
plan.
in that event, the power is there to the block development officer just to give impetus to his work which has already been executed.
Yes,
And somebody has, because I find in the act also that the Panchayat is empowered to borrow the money, to take any deposits and then pay. That power is there. So that's why it says the any amount which is collected or to be refunded out of the deposits, that will be made.
yes. So,
But prior approval of the chairman is necessary
So-
in that regard, because within the budget, no prior approval is required.
within the budget, I'll take your lordship. Within the budget, I'll take your lordship. What is the
Is the
clause?
committee will take a
No,
decision.
no, rule 91 can list. Just see rule. 3-line rule. Just 2.5 lines rule. Rule 91. The chairman of the Shamiti shall not,
What is?
rule 91.
Yes.
The chairman of the Samiti shall not authorize any payment in contravention of the provisions of the Act, rules, or orders issued in this regard.
Yes.
So, the question of the chairman's power with regard to authorization to the block development officer is under Rule 90. Rule 90. Chairman has to authorize the.
Why you use the word 2.5 sentence?
Kindly see two, I said lines, not sentence, lines.
2.5 lines.
Line. Even less than that, little less than that.
No, even a Nyaya has 2.5 words.
Not asking no words. I said a sentence of.
Nyaya
Yes.
is 2.5 words. That's why I was correlating. But are you going there? That should be a Nyaya.
Of all these I'm trying to show, my lords, as your lordship has rightly said, that in order to, with the chairman's prior approval beyond budget and chairman's authorization in all other cases, Rule 4 and 91 are those two safeguards which are there to govern them.
Chairman is a part of the Samiti's decision. Yes, you can end this. It is not having that particular independent right in that sense.
No.
He exercises those powers deriving from the
Samiti, the Samiti, yes, ma'am. Very
So
correct.
that is why one has to understand that that's why you're saying in order to just create a a link between also those provisions. One has to assign the interpretation in such a way.
Yes. So it's given its full effect. It's given its full effect. But today also, I'll not be wrong in saying there are certain developments taking place in between. But very recently, 2025, the government has issued a guideline. No work of a Panchayat Samiti, that is Finance Commission fund, should be less than 3 lakhs. That's there. So a guideline has,
I gave you an hypothetical example.
Yes.
That's the small work which does not fetch much amount.
yes.
So when
But let's see, one thing I can add.
that will be what it says, 2025, what
That is commission fund, that is finance commission funds, works are to be executed, but there are two, the Samiti works are to be executed on the basis of an annual action plan. That finds place in the act itself. Every year, Samiti takes a decision that what are the works to be executed, then how those decisions are to be
But
taken.
there are certain exigencies, there must be an exception which is to be taken into account.
Special meeting, special meeting,
It may not be perceived at the time of preparing a budget for the next financial year, may not. There may be some, there may be a casualty, there may be a national disaster. The natural calamities that may come. So nobody can foresee that what will happen.
Foresee that. Nobody can foresee that. That is the power of the special meeting of the Samiti is there. Urgent meeting of the Samiti is there, where the statutory notice is also dispensed with. They can immediately sit.
No, I am talking about in a financial part, sir. I am not talking about the management part.
Yes.
Sir, we are more concerned with the financial aspect.
Right. Right.
Then the control of the Samiti. Definitely the control of the Samiti is there.
Yes.
But I can appraise lordship. Since the 7, till today, lordship, there is no work available in the inter blocks beyond 10 lakhs, lordship. All are the small works, lordship. That's why, lordship, initially was 45,000. Now, then are 2 lakhs.
Argument,
So no works, lordship, all are lordship.
I've given a chart.
These menial works, as I gave you an example,
No, my lord,
the cleaning of the water tank.
no, your lordship's fair. See, I've given an estimate of all the works that have been conducted, my lord.
As rule 4, lordship gives protection.
And everything
That is
is,
small.
my lord, 6 lakhs, 65,000, 7 lakhs. There is nothing, my lords, which exceeds 10 lakhs. The government also approves 6 lakhs, 7 lakhs, nothing beyond 10 lakhs, my lords. And if your lordship, we have given the list of works.
No, I understand what you say.
My lord.
They are saying that everything is beyond 10 lakh. It's not factually correct. There are instances where it is below 10 lakh.
Yes.
All are below 10 lakhs. All are below 10 lakhs. my
Below,
lord.
lordship. All I'm saying, all are below.
So the
Because-
power is subsumed in this.
Means
Post 10 lakhs,
things
there has to be a tender. So that is why they don't want to get into
So far as
tendering
the
process.
tax aspect is concerned, it has not really come into reality.
Lordship,
So we are not going into this. Now we are concerned with the 2 lakhs.
2 lakhs. Yes.
As a parent.
Ma-
Now what to do with them? They are above 2 lakhs. And then the rule says that it is to be countersigned by the chairman as well.
Lordship, that's true.
2 lakhs are good.
Power.
And your lordships may see the treasury code. Under the Finance Act, there also, my lords, the treasury rules stipulate.
2 lakhs are
My lords, I have given it at page
491. That's
60.
all.
I have given at
2
page
lakhs, payment up to
Yes,
2
ma'am.
lakhs
Yes,
are
ma'am.
safeguarded by rule 4 and 91.
My lords, I have given it at page 67 of my writ application. The treasury code under the Finance Act stipulates, provided that in case of a Panchayat Samiti, withdrawal shall be made only on check, jointly signed by the chairman, vice chairman, and block development officer of the Samiti.
Sir,
So if the bill doesn't come to me, where is the question of me signing it?
then there is another aspect. One has to understand the meaning of the word withdrawal. Now, once you talk about the withdrawal, does it not connote that there is a cash money which is withdrawn from there?
These are checks, my lords.
No. Are it through check you have to withdraw?
Yes.
Can you go and just stand and give me the money
No,
to the
no,
bank?
no.
Nobody will give. There must be a negotiable instrument
Yes, my lords.
duly signed by the parties. So you have presented it. So withdrawal connotes any cash money to be drawn, to be taken out from the bank account. Withdrawal does not mean that any payment is made either through NEFT or through a check, which is directly credited into the account of whatever the person who is entitled to it. That cannot come into the withdrawal. It's only debited and credited.
My lords, we'll show you.
The banking withdrawal word is always used when we take out.
When we take out cash, no, as per the Central Finance Committee, my lords, we have that notification. We have to give the, we have to give the dongle. Digital signature, which then it will forward that amount. My lords, I'll give that circular to you all.
Certain things which cannot be paid directly through a check. So what they want.
That is why we pay in cash.
The cash money must be there in the hands of the committee. So that certain expenditures which are very minimal and very fringe, those can be met up. In that, so for that withdrawal, the safeguard is that everybody has to sign.
Yes, Pallav. And here there is a digital signature.
Section 39, if your lordship would kindly see, meets the exigency as your lordship proposed. Section 39 of the act, kindly see. Extraordinary powers of collector of this. Let me read it. In case of emergency, the collector of the district may, subject to the approval of the government, direct or provide for execution of any work or the doing of any act which a committee or its chairman is empowered to execute or to do, and the immediate execution or doing of which, in his opinion, necessary for implementation of developmental plans or safety of the public, and may direct that expenses executing such work or doing such acts shall be paid out of the fund of the something. Your lordship was exactly saying this. Now, 2 says, if the expenses is not so paid, he may make an order directing the person having the custody of the fund to pay it in priority to any other charge against such fund. Such person shall, so far as funds to credit of the Samiti admit, be bound to comply with such order. So this takes care of the situation. The collector's power is there, approval of the government is there, and they can do it. But so far as other parts are concerned, as I suggested, my lord, Rule 4 and 91 and safeguards to that 2 lakh. That cannot be unfettered. That has to be, balance is to be done in consonance with Rule 16, 4 and 91.
Otherwise, the elected representative is left high and dry.
Sir, what are you talking, sir? That's why I say that decision-making power is retained by the Samiti.
Provided that the bill comes, my lords. The bill is not presented.
I'm saying, you have to just understand and you have to, I think, retune the mindset. I was finding a very bad word, so I just find the milder one. Retune the mindset. You do not. Again, one has to understand that I have a power to take a decision that what work should be done. Samiti, why the Panchayati Raj is that at the village level, the development work should be ensured, because it cannot be ensured through officers or the executives who are sitting at the Sadar or in a district headquarters. So to reach the peoples at their place, this Panchayati Raj system was introduced so that the villages, they may take a collective decision through an elected body for their development. So this power is still unfettered. It has not been abridged to any extent. You are the person who is to take all such decisions. Once you have taken a decision that this has to be done, only thing is that you will ensure that this work is done. You will definitely see that the work is done in a satisfactory manner. So far as the payments are concerned, which is also before the submitting, because you have to just go through while executing it, that what should be the amount of the expenditure which one has to incur for this work. This is also there, estimate. Once you do it, now so far as the payment part is concerned, you have already taken a decision that this much of an amount will be paid, has to be spent. This is within you. Satisfaction is within you, means the satisfactory work, not satisfaction of the payment. I'm not talking about satisfactory work is within you. Everything is within you. Only thing is that how the amount is to be disbursed. I think retuning is required. Who will sign? I think some broader perspective is.
It's not a question of signing, my lords. It's a question of presentation of the bill. My lord,
What is the purpose of the bill? If the work is done, and if they come forward and say that I have already done, and this is, there must be some person who is monitoring the affairs that must be taken in the decision, that must be taken a decision by the Samiti, entrusting somebody to monitor it that the work is done. And if he satisfies or the Samiti says that the work is done, then the bill is presented for that particular work which is done. Only thing is they have to collate, yes, the work has been done. this is all the documents have come, satisfaction part, and then release the payment. Problem here is who will hold the pen?
In fact, Lordship, crux is elsewhere, Lordship. The government, Lordship, by of notification, has come up with all works will be executed by the junior engineer, not by other agency, Lordship. Their official work orders will be in their favor, and bills, they will be signed their bills also. That is the whole difficulty, Lordship.
Where I will get it, I do not get it.
Lordship, kindly let them
I
answer,
do not get
Lordship.
it. I do not get all this.
Lordship, the by of notification.
I do not know from where you got it.
Lordship, that is the practice, Lordship. Let them answer, Lordship.
Yes, we do not.
Lordship,
That's why we wanted to highlight.
Lordship, I will supplement the document.
Highlight that what is the modality
Lordship.
which is there in the rules, what should be done.
Lordship, what now the by of
There is
notification.
the notification,
They have
this one, table 1, junior engineer, assistant engineer, assistant, up to 5 lakhs.
Reality, sir, it has not been placed in the legislative assembly.
Yes, Lordship, that circular.
That has not come in. Today, we are concerned with the original 16-1.
Original 16 month at
That's
2
all. We are
lakhs.
not concerned with the amended.
No.
If they come with the amended, we will see that whether this usurpation of power through a circuitous route, whether it is public. We will consider that.
Subject to, if I'm not wrong, that is also not placed before the assembly, that 2002. This should come.
What we have found, that it has come in final decision.
Yes,
The
yes.
draft has been finalized.
Yes,
But as you have said, whether 57(3) is complied with or not. If 57.
And they have admitted in their opposition that 53 has not been complied with.
Lordship,
and the rule
57(3).
yes, rule has not come into force.
So we take it as.
So this has to go.
They say that rule has
That's
not,
why we say we take it that stand.
yes, and your
On the face of the admission manual, this has to go.
and in the official gazette, they are saying.
Was the proposition of law that if this particular prescribed mode is provided, whether by virtue of a notification, can they bring any amendment in the rules? Can they do it, or it is mandatory? All this line of judgment. from
You know,
Nazir Ahmed-
procedure they
from-
can't do.
Nazir Ahmed
that is
Directly
different,
there.
90,
Nazir Ahmed 1936 previous.
and that 99 Supreme Court below that Kerala Bar Association case.
Yeah.
Even that university case.
University of.
What is that university?
99 Supreme Court. Babulal Ghosh.
No, university.
99 Kerala Bar Association.
On the opposite, whether by virtue of this notification, can we amend the rules? will it come into operation? Or it is still at the draft 357.3 has not passed.
They, that very notification says that it shall come into force the day it is notified.
Notified.
No, it is notified.
It is notified.
Notified, you have not.
It's notified.
September.
They have notified it.
September 25.
Yes, yes.
You have not given it.
Sir, that was- we have given for
No, not notified, gazetted, no.
No, that is
Not a gazetted mark. I have seen.
There are
Sir, there is a draft.
It's a draft. It's a draft.
Oh,
No, it's the official gazette at the top.
I have marked it. Read that. In exercise of section 57.
57.
It is not draft. After draft, objections have been invited, thereafter they have.
They have come up with this.
Yes, you have not explained that.
Lordship, I will. Last two.
It is there in our writ application.
We have filed, sir. This document we have filed.
We have filed Annex 1, that is at
What I have
WPC.
found is not that which has the caption of the gazette. You not find.
What is this?
Annex 2, that is 27724 of 2025.
Because I'm looking at this particular expedition where the annexure 1 does not relate to that. It
They have
is,
gazetted it on 4th September 2025.
it is not an official gazette. They have just printed in this fashion. This is a draft, the amendment,
Yes, yes.
but it was not that it is published in the official building. So that's why we are,
I think this is the publication.
Other case is 27724.
Yes, sir.
Which page?
9. Your lordships are correct. We have only filed the draft. Your lordships are having this final notice.
Final notification.
Right, right.
That is another gazette, actually.
No,
That
it
is
is,
another.
it is, we spent quality. Because you have not enclosed.
No, my lords, this one I'm not.
that is what I'm saying. But this Odisha Gazette, this caption is not there anywhere, so we were under the impression.
Now you have to amend work there as well as your reading.
Yes, sir.
Would your lordship see?
Perhaps after your.
3498. Lordship, 34989.
Before
I
that,
listen page 15.
34989. Wait, one minute, Lordship. 34989, Lordship. Last 34989.
last one.
Mohan, Manas
Manas Jet.
Manas Chandra.
That is not.
That is not here. Oh, yes.
269. 269.
No, 34989 is not here, 26983 is here.
34989 is not on board.
No,
No, no, yes, no, yes, no.
not on board.
It's not in board, bro.
Very connect the three, prepares the thing and then forgot everything.
And we are arguing as if this is on board.
Now it has to be declared. He has to be declared.
Yeah.
His briefing council is not up to date.
3498. Manajana is earlier one.
Lordship, that is their Lordship. 2698.
9, right?
The full portion, these are basically.
Earlier it.
Only the portion.
No, this is not on board.
Not
34989.
This
This is not a recent, actually those matters were tried before. This has come on 19th of September. As the paragraph 2 and 3, 2 is very important.
Lordship.
It says that whereas the objection and submission received within the apposite period means 14 days.
14 days, Lordship.
In respect of draft has been duly considered by the state government. And then now in exercise with the power of the 7th, we have now, it has come into force.
Right, sir.
The question is whether it was laid before the legislative assembly or not. It's a question that has to be taken into account. Now it has come into reality.
Yes.
Lordship, Para
We
10.
have to amend. 19 September 2025.
No,
Lordship, can you say the counter paragraph 10, Lordship? They have admitted.
not suggesting to amend directly.
Only done.
We have already challenged it in this matter. It has
Then
not
this
come.
has come, sir.
No, Lordship, we have already challenged that rate of
We have
8% not tagged, Lordship, to this.
It has not come on board.
So, we'll get it and do it.
No. We are, in fact,
Sir, they have not filed that counters.
No, they have already filed counter, Lordship. In para 10, they have stated This is come into force and Lordship kindly para 10 Lordship counter.
So,
Lordship.
so you are.
When you find the regulation,
That is High 12 Lordship. High 12.
so it was already there. So
No, this Lordship, we have annexed that gazette
these rate petitions which are listed, when you file them,
prior to that Lordship. That is.
They're all at the stage of draft.
prior to 19 September or after 19 September?
Prior to Lordship. Right, 21 Right.
21/9/25, these matters are filed
After.
definitely after.
But needs it's of
First,
needs an amendment.
first prescription, that is 27234.
Make a,
That
make
you
a,
have-
make a, make a, we are granting a liberty file a small.
Lordship.
The date of your filing of first
Date of
prescription,
That
27234.
No, it is a technical one. There is no difficulty.
In the office,
Still,
You have filed on 22nd.
September
Gazette was
notification.
on
I wait for the assembly for
Yes,
8
for
days.
that is not
and
a
17th session.
application.
And for next 6 days, it will be placed in the next session. That we have specifically stated.
Test of not, no.
It has been placed for 8 days.
They have given a
The first
statement in para
session.
10 Lordship.
Seven-
Para 10 of the counter. They have
And for
given a
next
statement.
6 days, it
that
has.
you have disclosed in your.
Yes.
Blood maybe pardon me not
What is his contract?
Minus 3 years. There was a doubt in the registry's mind whether it will be
It's
a
a classification of the case.
Yes, whether it will be a meat appeal or a contempt appeal.
no.
Now, what has happened in this case is, my lord, contempt was dropped by the Honorable Chief Justice sitting single that the compliance has been done. And thereafter, my lords, after like 10 months, an IA was filed in a disposed of contempt application. The Honorable Single Judge, then the bench again, it goes back to the Honorable, another Honorable Single Judge. He takes a view that his own earlier order of interim, some interim order was passed. That has not been complied. So on that ground, my lord, he revives, passes an order on a dropped contempt in an IA. That is how, you know.
Why it will be a contact? Classification.
It's a writ appeal. It will be a writ appeal as per the.
That is what I think. Why
That is how,
contact?
my lord, we have filed a writ appeal. We have filed a writ appeal.
Then why you have filed an IA for conversion from the.
That is because when the registry said that asked us to file conversion, that it will be. It will not be.
They do not list it. For listing purpose.
Only, it will not be a contempt appeal. No, it will be a writ appeal.
I'm just trying to. The procedure here is very, I do not want to say any words. Suppose.
State that they have complied with the document dated 1
Yes.
April 2015 passed WC, that is single bench.
Mala,
Single bench,
Mala.
which is confirmed by document dated 5/3/2024.
Form means what?
Writ appeal.
So that means the main matter, when the main matter is carried to a appellate court, then the appellate court affirms the order.
Confirm the order.
Then in that event, it attained finality so far as that order is concerned.
Confirm.
Now, he has approached the single bench and filed an IA.
No. He filed a contempt.
Please kindly try to understand what I'm saying. A contempt proceeding is filed. Again, I have to argue like a lawyer.
No. Probably the facts are little.
I'm telling you, a contempt proceeding is filed alleging the willful or deliberate violation of an order passed by a single bench.
Right.
Correct? That contempt proceeding was dropped. Means the contempt comes to an end.
Right.
The order dropping the contempt was carried to a intra-court appeal.
No,
and
order, no,
that
no,
is confirmed or affirmed.
no, that is not correct. And that's what I wanted to clarify. The order
What is
of
the meaning of
regularization,
this confirmed or
no,
affirmed?
no, order of regularization. Order of regulation was carried in appeals.
Just
No, no.
confirming the.
What let me kindly, there are 2 minutes, I'll just explain. Honorable single judge passes a direction that Mr. X is to be regularized. No dates and nothing has been given. So that direction for regularization was carried in appeal. But while it appeal was pending, a contempt was filed. That contempt remained pending. It did not touch it.
In the meantime, the appeal got disposed of.
Appeal,
Affirming the order of the single bench.
man, it lay over for 3 years and then got disposed.
Whatever,
Man,
sir, it ultimately it affirmed the order of the single bench.
then the appeal was carried, then the appeal was carried to the
Appellate
Supreme
order,
Court.
not appeal. Appellate order
Appellate
was
order was
carried
carried to the Supreme Court. Supreme Court
to
confirmed.
SLP.
Man, over.
Okay.
End of the story.
Then the contempt.
Then we
went
came, man, here I will just take a pause. Then we came back. We regularized the man from 2020. That is the date on which the Supreme Court passed the order. Then he files a contempt. He revised that contempt. That contempt.
Sir, again you are missing a link. Please, that's why I'm saying that that creates a confusion in the mind. You said that in the writ petition, an order was passed for regularization of the service of Mr. X.
Man,
That order was carried in an intra-court appeal.
yes.
That intra-court appeal, the appeal was pending. In the meantime,
No.
the contempt application was filed,
Man,
alleging the non-violation.
man.
Obviously, we can perceive that there was no interim order passed in the appeal.
No, the appeal interim order subsequently was passed.
Okay, that was also
Passed. So
then the contempt remained pending, and the appeal is also pending, was pending.
man,
Ultimately, the appeal was disposed of, affirming the order of the single bench.
man.
That
Man.
does not mean that the contempt was also
No.
disposed of. No.
Contempt, no.
Then this order was carried to a
SLP was
SLP
dismissed.
Then that contempt appeared,
Man,
and on the basis of the statement that you have carried out the order, or a contemptor has carried out the order, the contempt proceeding was dropped, as you said.
no.
Contempt was dropped.
They said, you comply with the order within 3 months. So
It
we,
means
man,
the very innovative concept of first, second, and third contempt is
man, that.
from where it originated. I do not know. Under the law, I must admit my
No, man,
non-understanding of this concept or a wrong understanding of a law.
man, we are not getting into that, minutes.
I have learned the wrong law.
Man, that's a practice that has been happening, but
I
so
do not
therefore,
know.
man, without going into all that, minutes. Now, from 2020, the facts that
Then the contempt which was pending during the pendency of the appeal
before that
was disposed of with further direction to comply the
initially, madam, yes, it was disposed of on the finding that 2020 he was granted regulation from 2020.
Sir, again you create a confusion.
Let me
Again I am saying you create a confusion. At one go you say that the contempt was, there was a direction within certain time you dispose of. Now you say, since it has already been implemented from a particular date, this creates another confusion in my mind.
I'm not
Why?
possibly I'm not clear. I'm not clear, Malaks. Possibly I'm
Division bench, where I was party. There it is made clear.
Now the case like this, I have.
This
Appeal against the original order regularizing the service. He has two things. He said, the university. So he said, past my of this court in Defendant of 2017. There's the order of surgery was a challenge. That is what I am asking. He's not saying at all.
There's a problem. Disposed of in 2016 and WTC number so and so disposed of 1/12/2015.
That means
That's
the
the
two orders, one original order of regularization and the order dropping the contempt
Yes.
challenge.
So where I was party.
He's not saying so.
The 98 is 98. Come to page 98, paragraph 2 and 3. It transfers from the ordinance based in present and other material from that is one number 1 have filed the restriction which was just for to scale to be from 1/12/2016 with the following observations and directions. That is paragraph 3. Paragraph 2 clarifies that content dropping the proceeding that was challenged as well as the single this order was also under challenge. In writ appeal. So in that context, we have not interfered with. Thereafter, Honorable Single Judge has
That is where you are.
IA.
Thereafter, your lordship send it back to the honorable single judge, saying that paragraph 10, page 105. Learned single judge in a contempt proceeding could not have gone beyond the scope of the direction issued in the writ proceedings. Mr. Pilot contends. There is no quarrel, paragraph 12, over the principle that even an interim order passed in a contempt proceeding in appropriate cases can be subject matter of challenge in an intra-court appeal under clause 10 of the latest patent of Patna High Court. However, we are of the considered opinion that it will be open for the university to take such a plea as may be available to it to satisfy the court hearing the contempt proceeding that there has not been any disobedience of any terms of the order passed by the learned single judge. In the present facts and circumstances of the case, we are not inclined to interfere at this stage. The present intra-court appeal. Then, my lords, we
Whether the property orders or something of that kind, whether it is maintainable records, they are ready to take. But ultimately, you did not interfere with the order. That means this one was also not taken into consideration.
thereafter, my lords, the next order, Annexure 15, 106. Thereafter, my lords, the next order, your lordship kindly come to the next page, 106. This court is prima facie satisfied that the order, that this court's order, violation of which has been alleged in the present contempt application has been disobeyed, constituting contempt of court, inasmuch as the petitioner has not been given consequential benefit. This is the only core question. This is the sole question.
That is single bench.
Yes, Honorable Chief Justice, whether such disobedience is willful or not will be considered on the next date when the matter is taken up. Thereafter, my lords, this. Thereafter, he was paid the consequential benefit of my lord, all the entire consequential benefits were paid. Then, my lord, the next order, page 116, Annexure 19. That is order dated, subsequent order of the Honorable Chief Justice, 26/7/2024. This is subsequent order. From a compliance affidavit which has been filed on behalf of the university, there does not appear to be any dispute that this court's order, violation of which has been alleged in the present contempt petition, has been complied with. So the contempt was, the violation was complied. The learned senior counsel, appearing on behalf of the petitioner, has however submitted that the petitioner is entitled to regularization from the date of his joining, which has not been done in the present case.
It's an independent cause of action.
Independent cause of action, that is my point. the petitioner shall be at a liberty to ventilate his grievance before the appropriate forum in accordance with law. The contempt petition, next page, accordingly stands dropped. This is the order, specific order. Thereafter, my lord, he approaches the university under Annexure 20 on 8/8/2024. The next page, 118. He makes an application for regularization of the services from 6/11/1995. That is another cause of action he ventilates, which the Honorable Court did not interfere with or made no observation on that, only said that you can approach the appropriate authority. He approached the appropriate authority in a representation dated 8/8/2024. Application for regulation of services from 6/11/1995. Order of the Honorable High Court of Orissa dated 26/7/2024, passed in contempt so and so. Contempt number 1383 of 2017, arising out of WPC number 1148 of 2005, disposed of on 1/12/2015. Your application dated so and so, so and so, so and so. Your application dated 27/2024 and dated 3/8/24 were examined with reference to the judgment dated 1/12/2015, passed in WPC number so and so, and the order dated 26/7/24, passed in contempt 1383 of 2017. As revealed, you have never been engaged against any vacant sanctioned post. Further, you have not been engaged through a regular selection committee intended for appointment of regular
Citizen of the organization.
My lord, this is the authority.
They refused to accede to the prayer that their regularization
Correct.
will take effect from the date
Correct.
of first initial joining.
Correct.
Because
Correct.
there was no vacant post.
Rightly or wrongly, that's
Sanction vacant
My-
post. Yes, then whatever.
Thereafter, my lords, in that contempt which was disposed of in 2024, he files an IA. An IA number.
Single bench of honorable judge.
Yes, then it goes back to the same honorable single judge. He files an IA number 145 of 2025. He works for 10 months as an assistant professor, takes his salary, 15 lakhs he takes arrears. He takes the salary, works for 10 months. Just before the expiry of 1 year, my lord, just 2 months before, he files an IA saying fraud has been committed and I have to be given, and the order has not been complied, and I have to be given appointment from
What was the original order which was passed?
this.
Regularization.
Grateful one. This was the order. And if you are true, it's page, that is that page. 32. No, page 44. Paragraph 22.
Is 32.
And if you are true is. And if you are true is 30. It starts at 32. Starts at page 44, paragraph 22. In that view of the matter, no, I'm sorry, page 21. No, paragraph 21. No doubt, after establishment of BPUT, the institution under the control of BPUT have to fill up the vacancies in accordance with the provisions of the BPUT Act and rules framed thereunder. If the institution has been taken over along with the staffs, in that case, BPUT has to take necessary steps for regulation of the services instead of terminating them, though the employees have not been appointed under the provisions of the BPUT Act and rules. In that view of the matter, this court is of the considered view.
No, that does not really say that from which dates.
No, it does not.
Does not talk about it. Says that in accordance with whatever
Man,
it is to be done. Now, what is the interim order or what the violation has been alleged in a
he violates,
application
Manas, this.
that you have given effect from the date of the dismissal or order of the SLP?
This is the order. In effect, the Honorable Single Judge wants us to implement this direction. Page 96. Order dated 7/2/2024, against which we came up in a writ appeal, where my Lord Honorable Justice Raman was the participant. This was what was challenged in writ appeal. Order dated 7/2/2024. That was passed in the contempt.
page 96. Matter is taken up.
But this was not interfered with.
My lord,
This was not interfered with by the.
subsequently, this merged with the other order. Final order was passed in the contempt. 1383, final order was passed in the contempt. We came before this honorable court saying, contending that this is a direction on merits. So therefore, this could not have been passed in a contempt application. No observation on merits could have been done. It's either compliance or non-compliance. So this was entertained and then it was remanded back.
What is the ultimate order which was
Passed in the contempt. In the contempt, this page, paragraph 100 and page 116 and annexation 19. Compliance was filed on 26/7/2024. From the compliance affidavit which has been filed on behalf of the university, there does not appear to be any dispute that the court's order, violation of which has been alleged in the present contempt application.
What was the violation? Which order was sought to be violated?
This one, the other one, annexure 2, which I will just read.
In the contempt.
Annexure 2. Entire thing is against annexure. The core is annexure 2.
Page.
Page 44. Paragraph 22. No date has been given for compliance.
Paragraph
22. In view of the matter, this court is of the considered view that the opposite party should observe the petitioner on regular basis against sanctioned posts, taking into account the length of service rendered by him as a lecturer in mathematics, in which he has been continuing, without insisting him to undergo the rigors of selection process laid down under the BPUT Act and rules framed thereunder. Reason being that in the meantime, the petitioner has become overage and has also been exploited for 20 years for no reasons, though he has qualified in all the interviews conducted by the authorities for his engagement on contractual basis. The petitioner being not a backdoor entrant in the service, the opposite party university should extend all consequential benefit as due and admissible in accordance with law as expeditiously as possible, preferably within a period of 4 months. So we gave him from the date of this judgment. Eventually, ultimately, we gave him from the
appeal of 4 of 2016.
Ultimately, we gave him from the date of judgment of the Honorable Single Judge with all consequential benefits. And he worked in that. And thereafter, an IA has been filed. So therefore, my lord, just the order before that.
It is 2019, just Senate order of the number 111 of 2005 was challenging the appeal number 4 of 2016. And this was affirmed at page 64.
Yes.
Then
Against that, we went to Supreme Court. Against that, we went to 1664 in the Supreme Court. SLB was dismissed.
So there was no challenge to an order passed in a contempt. It was a simplicity order passed, order dated 1/12/2015, which was challenged in the WA 4 of 2016.
16, yes. In fact, just before the present impugned order, the order that is impugned in the present proceeding, just before on the last day, when I pointed out, when we argued, Annexure 22, your lordship may kindly appreciate, page 121, we argued specifically before the Honorable Single Judge that under which provision has an IA been filed in the Brock contempt, in the disposed of contempt application, not under High Court rules, not anything known in law. Then the Honorable Single Judge passed that order on 11/11/2025, your lordship may kindly appreciate, page 121, Annexure 20.
It says written notes, you filed.
Yes, written notes clarifying to the petitioner, not me. To the petitioner, clarifying on the power of the court to entertain an IA. And he files no written note, nothing on record. And then suddenly, my lord, the next day, the argument is closed on the next day, saying you comply, it's not been complied. And today that Contempt is non-existent. It has already been dropped.
The matter is still listed.
It was listed today.
Today it was listed. It was there. We have taken time saying that.
13th.
How can matters? As on
If it will take such a long time, anyhow. I'm ready on next one. It's 7.
My lord, kindly tag the matter with
About that.
Item number 7.
apology, my lord, apology, kindly tag with him.
Why we tag? We don't know whether they are interconnected or not. Why our mind, we have to see this procedure. I have seen many times it says wrongly that.
No, it is the.
So we will decide the matter on that day. You just tell us, we will decide that matter as well.
Okay.
7.
Item number 7.
Milord, that item 2, Milord, may I be pardoned?
Item 200 pages.
Milord, this item 2 is an important matter. If your lordship recollects, the other day I made a mention, it was directed to
Mr. Acharya,
my lord.
the learned counsel is not available. She can only be available after lunch. So
No issue, Milord, I have to wait.
there won't be any possibility to take up matter. So we are fixing it on Monday.
Milord, actually, there is an interim order. It is for the procurement of animal medicine, and the read petition making the same challenge has already been dismissed. The same tender.
Then come at 2 p.m. Come at 2 p.m.
2 p.m. That is the reason we have.
If it is dismissed, then we'll come at 2 p.m.
That's correct. The same challenge, the same tender.
Yes, if it is already done, then it's done.
That's correct. That's correct, Milord. I'm deeply obliged.
Item 7.
Kind of a PIL is there. What kind of PIL is there? The merger of that particular Kendrapada with the Cuttack is up to you.
It's up to the Postmaster General. Usually Mr. Pari, he appears for the Postmaster General.
None appears in support of the petition 2 weeks.
Item number 8.
Action of the opposite party thereby the statutory direction of the government.
So again, sir, the coachal lands, constructions are going on. You are not taking any steps.
We have already, Milord, we have stopped the enforcement, Milord. The construction that has been stopped, Milord, and an enforcement case has already been initiated. Milord, so
What can be done? So entire grievance has been taken care of. They have already instructed, they have stopped the construction work, they have already initiated a procedure that they have to under the law. So your main grievance is this.
stop the construction.
They have stopped and they have also initiated proceeding for their eviction. What
They are
more?
taking steps also for de-reservation in favor of some. That is
But
different.
why will go into the instant repetition in the nature of the public
There will be a case in oxygen in the form of public interest litigation. But we kindly see the land, which is only meant for celebration of Maga Saptami, which is lying at Chandravada University.
Yes, what decision has been taken? This is, they have said that it is the place which is being used and utilized for years together for performing the religious, the ceremonies or rituals. You are constructing a toilet
That's form. Only 2 minutes.
Which for the other side?
Ladies come.
It's 28.
Which matter?
Item 28.
28.
Item 28.
My lord, we have filed it in the counter, annexure B/2.
Don't go for a counter. We just wanted to look at that judgment.
Close.
My lord, the same judgment, my lord, which we have annexed for the convenience of your lordship.
First, tell me that what they have sought for in this.
My lord, they have challenged two tender terms and conditions contained in paragraph, my lord, 5.
1 crore 20 lakhs quash the clause 5.2.8 of the tender call notice as unreasonable and arbitrary and fixing EMD to the tune of 1 crore 20 lakhs.
Absolutely.
Exorbitantly high. Now, where is your counter?
That is, my lord, your lordship may kindly turn to the another clause. There are two challenges. This is one, and the other
Where
one
is
is
the-
on
You're
page.
talking about a judgment dated 18 December?
My lord, Winners Pharma, that is, my lord, the judgment of, no, counter, the judgment, my lord, I would request.
Winner Pharma. Winner Pharma. Winner.
My lord, the Winners Pharma.
Winner Pharma. That is.
Where is-
Pharma, my lord, for brevity.
Oh.
85, page 85.
My lord, the same tender, the same clauses
P/2 in counter.
at page 85, your lordship would find. It's a division bench judgment. Very same tender, another prospective bidder, he raised a challenge to the same clause 5.2.8 and also the EMD criteria. And that has been, my lord, by an elaborate judgment has been dealt with and dismissed, my lord. He is another prospective bidder who raises challenge to the very same clause. It's a division bench judgment and the same clause that was dismissed in January 2025, my lord. There is an interim order. This is for procurement of veterinary medicine. And my lord, the very same clause, your lordship may kindly turn to the prayer portion.
Yes, yes.
Clause 3.1 and 5.2.8 of the impugned order, notice dated 9/12/2014, my lord, that would be 24, my lord. Issued by the Director Annual Husbandry Manglabag under Annexure 6 shall not be quashed. The very same annexure is the tender call notice, which is impugned in the present writ petition, and ground of challenge is the same. 3 years consecutive average turnover 4.5 CR. That is
So anyhow, sorry, I have read the entire judgment. That is at page 85.
my lord.
And I find that this 5.2.8 was really the center of challenge in the said writ petition. Ultimately, the court says that it is not unreasonable.
That's correct. My lord, your lordship have also laid down a very beautiful judgment in Utkal Suppliers that the tender terms and conditions, my lord, that judgment also I have given your lordship sitting with my lord Justice Raman.
No, this is what is that judgment? Which
Utkal Suppliers.
that is also annexed here, I think.
No, I have not.
The 18 December. 18 December order. It is annexed here, I find.
I would request Mr. Tripathi to pass over that judgment. Please. Utkal, I have given it, my lord. It is maybe there.
My lord, I am extremely sorry that the called and not there.
My lord, for last 1 year, this, my lord, this another prospective bidder who doesn't have the turnover and doesn't fulfill the eligibility criteria as per the technical terms and conditions of the tender. And, my lord, the division bench has already passed the judgment dealing with these aspects, relying upon Tata Cellular, Michigan Robber and all those. And this series of judgments your lordship have very expressly dealt with in this Utkal Suppliers case, which is a 18th December judgment, my lord. Para, my lord. Lord, para it also the very same one pharmaceutical case, my lord, was dealt with by the division bench of Madhya Pradesh High Court. In para,
No, I got it. Yes. I got it. Now, madam, only one aspect.
I am
Because-
extremely sorry, my lord.
No issues.
My point.
Only one point.
My lord.
Because the same the terms and conditions, 5.2.8 was a subject matter of challenge before the coordinate bench. What are you talking, madam? Come to page 85 of the counter.
Date of admission.
Please,
Yes,
on the
I know.
5.2.8.
That is why the dummy bidder.
What dummy bidder? That's a,
The date of, exactly I'm coming.
whatever be the reason, on the date of admission or on the date of final hearing, that is a different
Judgment.
Matter.
The judgments that about Tata Silver, everything applied in vacuum, that has not been examined whether the conditions are arbitrary or not.
Madam, what you are arguing, you are arguing before a coordinate bench.
My lord,
If the other earlier coordinate bench has taken a decision,
my lord.
is it not binding on us unless we take a dissenting view and then refer the matter to a larger bench?
Because that is not examining the point.
Now, once it is, we do not find, once it is said,
One judgment I have come up with this.
yes.
That is, what is the factual dispute that has never been? That is, this court has restrained the judicial review, power of judicial review. That was the judgment. My lord, kindly see. Why I am saying this para 26, my lord, kindly see. Where is there is a factual, exactly the same party, my lord, approached this honorable before this coordinate bench. Your lordship declined to pass an interim order but issue notice. And thereafter he withdrawn, my lord. Even if there is no interim order, but there should be question of admission.
No, this has no application in the instant case, madam.
Because,
Again, I am saying,
my lord,
madam, please consider
my lord.
a coordinate bench on the same cause of action has taken a particular view. Please consider, has taken a view. Maybe on the first day of the admission,
Right.
maybe on the last date of the submission. It is immaterial.
Right.
A decision has been taken by a coordinate bench. I believe the law is now well settled that the decision of the coordinate bench is binding on the another coordinate bench.
My lord, that's when there is some ratio is decided. Here, my lord, no. Here, what is our challenge or allegation that has not
One
been decided.
judgment that the ratio has to be considered.
Your
shows
lordship, this coordinate bench, my lord, about this bidder, there is another order, your lordship declined to pass an interim order, and that is thereafter he withdraws that writ application.
So that means we have not applied our mind into it. That is what at the interim stage. This is a final order which is staring at our face.
On the first date of admission.
Sir, one judgment on a principle of law that the judgment passed on an admission day is not binding on the coordinate bench. I will be happy to understand this proposition of law.
What is that ground that
Sir,
taken by
madam, again I am saying when a challenge is made to a particular the terms and conditions of the tender and the court has upheld, the coordinate bench has upheld that it is not arbitrary, it is not caprice.
That's nowhere. But that is the point.
If the writ petition is rejected, what does it connote?
On the
What does it mean?
My lord.
That the court refuses to interfere with those clauses
That is
as the court does not find it is an arbitrary exercise of power, colorable exercise of power. It is actuated with malice. It is not a reasonable one. All these things have been.
But that is not been
Is
discussed.
not necessary. What can be logically deduced is this.
Only on this point, my lord.
When the dismissal came,
Page 3, my lord, para 3, my lord, kindly see. Para 3 of that judgment, page 88. Dismissal because in my lord, that but fact remains whether in the facts and circumstances that what are the facts and circumstances not been discussed of the case. This court in exercise of its jurisdiction under Article 226 of the Constitution of India can interfere with the tender condition imposed by the authority concerned. That is the basic.
that is your point here.
No, I think.
Sir, first thing is when you have approached the writ court, that means you are challenging a particular terms and conditions to be bad, arbitrary, illegal, irrational,
Yes, that
malafide.
discussed.
Please consider malafide
My lord,
to uphold that this clause cannot stand.
my lord.
Now, the writ court will first examine whether these cases have been made out for exercise of the writ pass, First thing is whether the writ power should be exercised or not. If the judgment says after taking into consideration, what is the difference between a judgment and order?
Then no ratio is this.
No, madam, when you talk about the order, tell me what is the difference between a judgment and order? Let us be very academic. Tell me first. When you raise this point, tell me what is the difference between a judgment and order.
Admission on the
I'm talking about.
Right.
Please tell me
No,
what is the.
no counter is no.
So according to you, if there is no counter file, then it cannot partake a character of a judgment.
And no ratio is decided in this case.
Even if the no ratio is decided, it cannot be termed as a judgment.
In this case,
Huh?
there is
No, this is your understanding of the judgment.
there must be a ratio.
Madam, I am unable to accept.
These arbitrary conditions without a counter on the date of admission, all the judgments have been taken into consideration. Your Lordship, kindly sit for a moment.
It's from the, even if it is not.
The sound make.
Page 90.
Very close.
What?
3.1 and 5.
I know my Lord, Lordship asking a very pertinent question, but that point is when that has not been examined, what was the factual case, how it is arbitrary. My Lord, this honorable court that bench has extracted the Tata Cellular, and which point, my Lord, kindly see. There is no question of arbitrariness whether any public contract is there or not, that has not been discussed. The apex court noted that there are inherent limitations in exercise of power of judicial review in contractual matter. As such, it was observed that the duty to act fairly will vary in extent.
Madam, with folded hand, can I invite your attention to paragraph 2.4 of the judgment at page 88? Please read loudly. When you say no case is made out of that, please read that paragraph 2.4.
Madam, that I'm reading. The specific case of the petitioner is that clause 3.1 of section 111 and clause 52.8 of the impugn tender call notice being contrary to rule 212I and OJFR 223 are arbitrary, irrational, unreasonable, discriminatory, qualified, biased, and violative of.
Any other words are used?
Yes, this is used by that of the Constitution of India, for which interference of this court is warranted.
Correct. So the court was considering whether on these grounds, whether it is arbitrary, this is illegal, there is a discriminatory, everything was considering. And then court says that whether it warrants any
interference,
such situation, inviting the interference. And then the court.
Discussed.
Now, please, then the court discuss the law on the subject. Please come to paragraph 3.
3. As is evident from the factual matrix delineated above, the date opening of online tender is so and so. It is at this stage, instead of participating in the tender process, the petitioner has approved this scope, questioning the tender conditions. But fact remains whether in fact and circumstances of the case.
Stop. In the facts and circumstances, as it said 2.4.
Yes. This court, in exercise of jurisdiction under Article 226, of the Constitution of India can interfere with the tender condition imposed by the authority concerned.
What do you mean? Then what the court was considering?
So Tata Steel is not a bad law, as on date. So whether there is arbitrariness or not, that has not never been discussed. Only the power self-restraint on the court. When there is a arbitrariness, then court can interfere. That is a settled position of law.
Madam, probably
Yes.
I'm breaking my head to it to convince you on some aspect. Please consider what the art of writing a judgment differs from a man to a man. But one has to understood after reading the entire text of the judgment that what that author of the judgment means when he says in paragraph 2.4 that the entire arena of challenge is founded on the arbitrariness, unreasonableness, discriminatory, malafide, bias, violative of Article 14, 91G, 21, 300 capital A. And then the court poses a question that whether, if it is so, what should be the scope and the jurisdiction exercised by the writ court under Article 230. The court then considers that under what circumstances the court should exercise such discretion or interference.
That was not discussed.
Please, Tata Cellular, Michigan Rubber was also taken into consideration.
Consider.
In my judgment, I have gone to Subodh Kumar Rathod as well of the latest judgment. Whatever we said that on these are the parameters. If the court ultimately says that I do not find anything to interfere.
Yes, my lord. That is exactly my case. What is the lordship is saying?
That means
My lord.
what can be inferred is that this clause is not arbitrary.
Yes.
This clause is not discriminatory. This clause is not unreasonable.
Exactly.
This clause is not violative of any.
That is my case before your lordship. What your lordship said, that has been never discussed nowhere. My lord, that is the petitioner case. That what happened, my lord? They set up a dummy petitioner so that it will be dismissed on the first day with all the judgments. So nobody can come and.
Sir, in paragraph 9 of the judgment, in the coordinate bench has said, in view of the above judicial pronouncement,
yes,
this court is of the considered view that in the matter of formulating conditions of the tender document and awarding a contract, unless the action of the tendering authority is found to be malicious, arbitrary, and misuse, interference by this court is not warranted. And then, for the going discussion, we are not inclined to accede to the prayer made in the writ petition. That means the court did not accept that clause 5.2.8 is arbitrary, malicious.
So I stated. Madam, kindly see. Madam, for a moment, page 70. Madam, I saw two recent judgment of the apex court in Orissa case, my lord. That is Santi Construction, where the Honorable Apex Court stated, even if a misinterpretation or interpretation narrows down the competition, then that should also bad in law. And accordingly, my lord, this judgment have been passed and was the
Madam, we are on the point of
that is not been exactly.
we are on the point of consistency,
That is
which has already been decided. Can we reopen?
That is what you say.
Madam.
Let me say that what I have perceived from the judgment. That is your understanding of the judgment.
Madam.
Let me say that what is our understanding of the judgment. Let us see.
Just for a moment, madam, kindly see page 70.
No, I know you are a formidable argument. The council, no doubt about it, but I think you know the law better. You know the law better. Still, you are
That is
insisting.
great compliment, my lord. If your lordship will say me, my lord, page 70, kindly see, page 70. For a moment, my lord, the writ petition. Just drawing your lordship's attention how this mafia is functioning. That page 70, my lord, kindly see.
Madam, again, I'm saying we are stuck up with
Yes,
with
that is your lordship.
the certainty
But
and the uniformity
yes,
and also the committee and the amity of the judicial discipline.
legal propriety, my lord, that I am not, my lord, kindly see page 70 for a moment, page 70. Page 70 for a moment, my lord. That to my writ application. The bidder, my lord, that's what I am challenging, must have 3 years experience in supplying veterinary medicines and vaccines of its own manufacturing of reputed manufacturer on national level to central, state government, semi-government. Kindly see.
I have seen.
Apare,
I have read faster than you.
from 2019 to 2024, there was no tender floated by the department. And this was the judgment, the same, my lord, the party, this is the judgment, my lord, this honorable court allowed it, challenging, there in Supreme Court confirmed it, that is Kamala agency. My lord, this is, they have challenged that condition of one of the tender conditions for 2022, and it has been allowed by this honorable court. And this is confirmed in the Supreme Court. That for that Kamala agency, Learned Advocate General was appearing and that eligibility condition was been quashed. And now that is
General was a private counsel then, madam.
Oh, that's right.
I'm in a
That is
different
very
world
good judgment
today.
and all the judgments have been referred. And it is not that arbitrariness cannot be.
Learned Advocate General has argued so many cases.
And I am entirely, my lord, relying on this. Without a counter, without issuing notice to opposite party, all the judgments have been referred and that has been dismissed on the same date. And they have not filed any counter. Government has not been noticed in this case. And thereafter, any case will come that will be governed by that. But that ground has never been discussed, my lord. That 5.28 is a arbitrary ground. And another ground, my lord, that is your lordship in your lordship's order, that general finance rule has a statutory flavor. So you cannot violate entirely the general statutory rule. That is the case, my lord. Kindly see this. And my case is entirely on this ground. This is your lordship's interim order, my lord. Your lordship has observed that general financial rule of 2017 has a statutory flavor. And they have violated entirely that finance rule. My lord, my submission before your lordship, that there is a judgment, but that judgment has not discussed whether 5.28 or 3.1 is arbitrary or not. That is my case. It is only on the inherent power.
So Kamala, we will take care of this, no problem. Anything more?
My lord, then another case, your lordship, my lord, kindly see that this company, this Winner Pharma, has my lord, this is your lordship's order, my lord, kindly see. Another writ petition also pending. Your lordship has been not inclined to pass any interim order. My lord, see that what I am submitting, my lord.
That goes against you.
Yes, I am submitting. But that means your lordship issued notice in that case. But that tender has not been finalized, but they have withdrawn.
It invites me a very, very interesting situation which was argued in another High Court. When an injunction applications are taken, the court declines to pass an interim order, but issues a show cause notice. as to why the injunctions are not be granted. Argument like this was advanced when the court has issued a notice that means the court has to pass an injunction order if they do not come. That was discarded, deprecated.
No. My submission is just reverse. My lord, kindly see that winner pharma.
When the
Yes.
court declined with the finding that this is not a fit case to pass an
Yes.
interim order,
My-
mere issuance of notice
No.
does not mean the court
No,
is still keeping that everything alive, was satisfied
my lord, that
that the
tender, my lord.
matter requires.
Yes, my lord, that tender I am filing one affidavit. In my case was pending just to frustrate that my case, this case has been filed by the winner. So that, and all wrong things have been.
And you are
no,
digressing,
no,
you are digressing
Yes,
from the
I
core
am saying,
issue.
my lord.
You are digressing from the core issue.
My lord,
That whether the judgment of the coordinate bench is binding on another.
my submission is not because that grounds has not been challenged. The grounds have not.
That's
been
all. This is what your main argument.
Right.
We will just discuss that whether grounds
And
were
before that, my lord,
there or not there. We will discuss.
before
on
that, one additional affidavit I am filing that the same bidder who has make it dismissed before a division bench, my lord filed a case before your lordship. Your lordship declined to pass an interim order so that my case will not get an interim order. That's still pending. My lord, and now 312, my lord, they have given to one family they have created monopoly. That is my additional affidavit. My lord, why I am saying that Kamala and National, they have got all the tender and withdrawn that lead application which was filed by the winner. Because, my lord, I am saying your lordship here is that in that case, the first way they have dismissed the writ application knowingly that let it be no other writ.
How many bidders were there? Must be more than one.
No,
No.
exactly that is the point, my lord. Kindly
Yes.
What single?
More than 1 million, more than 25 bidders participated in the
Kindly see
bid.
that they have allowed two bidders, that is mother and son. National and Kamala, they are mother and son, they are related within one family and two MSMEs. And no other bidder has ever been allowed to compete because they wanted to create from 2019 to 2024. 2023 and 24, my lord, they have without tender allowed them to supply.
See, open bid, Milord, what is submitting, I fail to understand.
That my lord, they have allowed to supply in 2020. All are there. My lord, kindly have a look to that my additional affidavit.
From loss
Just
is
for a
jumping
moment.
to some other thing.
And I have saying that they have given it the 30th 12 December, my lord. They have given the tender to Kamala and National, they are mother and son. And general.
You establish this relation of.
Does anything preclude a mother and son to
They have all
participate in the open bid?
their GST is there and that was
Digressing from the law and making all irrelevant.
and that is they have to say that whether they are and we have
The law of evidence says that one who asserts has to prove it.
we have given to the government.
Where is the proof for a document that they are mother and a son?
Then on affidavit I am saying that. And
On
everybody
affidavit.
knows. Everybody knows they are mother and son. Everybody, my lord,
It's a hearsay evidence.
no, my lord, they are, that is
How
the,
do you know?
because my lord,
How do you know? It must be from a particular government document.
they are mother and son, they are one GST, they have one,
It's a open bid. It's Milord making all
for a moment, my lord, kindly see.
submissions in
For a
a
moment.
read court. Let the scope your
Mr. Advocate General, even if it is an open bid, if there is a cartel which is evident
That's
from
correct.
court, then
It's a
definitely
cartel.
the court cannot shut its eyes.
No, you are right.
He's talking about a cartel being created. So we are seriously thinking about it and wanting the sufficient
No, your
evidence for the
is correct.
document to be
No,
produced.
that is not the case here, Milord.
So
Is the kind of, rather, Milord, the petitioner was earlier a selected bidder, 90 maybe blacklisted. I think she failed to supply medicine, equipment.
no, that is neither here nor there, that if it is a blacklisted one, then he
No,
cannot
we have stated it in the
participate.
counter, not blacklisted, maybe likely to be blacklisted. Your lordship can
Maybe so long that is
No,
not
we have
there, that
stated in the
cannot
counter,
come.
Milord. That is why if she is going to
Nothing.
merit, Milord, your lordship
Must establish us that they are the mother and the son from the document.
This is quite many cases.
is also humbly submitted. Milord, page
But
12.
National being the mother, has never.
Your Lordship may look at the
Madam, when you assert you are before the court of law,
Yes, I know, madam.
you have to prove it by a cogent evidence that this is what a mere saying on affidavit will not do.
Madam, on GST, I have applied for.
Sorry, we can't say it.
Madam, just
Can't.
give me 2
And
days.
they are party, they are represented.
I am not against them. I am against the government. Government knows it.
I am, when you are imputing certain allegations against them, are they not entitled to be heard?
Before this.
They may come and say that there is no connection, there is no nexus, there is no relation.
Mother and son, my lord, just 1 minute. That in additional affidavit, we have come to know that mother and son has been awarded. That additional affidavit in December.
Madam, where is the establishment of this relationship of mother and son? Sir, there may be two different legal entities who have been awarded a contract. That does not mean that they are related.
No, they're family.
I am asking you, where is the evidence?
System.
Wow. Established by mouth.
No, 2 days. My lord,
No,
it's
sir.
very
You are
difficult. All this. My lord,
vociferously arguing.
My
No,
lord,
we have given you an anxious hearing to the fullest. You have cited those judgments.
my lord, I'm
You will,
in
say
the interim order, it has been reflected.
Will decide.
My lord, interim order, it is reflected, but the government has never said no.
Merely coming and saying that.
My lord, interim order, it is reflected.
That will not. No, I'm not hypothetically.
My lord, not.
This
That is very difficult to.
Even if one actually, then have different businesses.
No, that cannot be. OJFR, my lord, that General Finance Rule 2017, the central government rule that is applicable to all state and our OJFR also, that cannot be any third parties. If he is connected to any bidder, that cannot be given. My lord, that is that rule. My lord, that is the rule, my lord. Kindly see. My lord, your lordship, kindly see my rejoinder for a moment, page 33.
Just a minute, madam.
January.
From you say that GST is one.
That I have, that I have, my lord, page 33 for my rejoinder.
Made out the case,
Yes.
does it?
That I will prove, my lord, page 33, my lord, for my rejoinder. For a moment, kindly see. That how this monopoly has been created. My lord, page 33 to my rejoinder. Under RTA Act, I got everything. My lord, in 2019 and 20,
What is this?
that my lord, kindly see name of bidder. Formal agency and national enterprises, formal agency and national all the 2019-20, these two persons have been awarded the contract. In 2023-24, without tenders, my lord, my lord, then another defect, my lord, in the tender that has not been discussed by the previous honorable bench. My lord, that must be rate wise because 147 medicine have been put into auction. So that I am a small supplier, I will supply 20. But they have not disclosed that rate wise, item wise rate. That is the OJFR and General Financial Rule mandates to do that. So that EMD can be 2 to 5% can be fixed on that basis of rate. What they did in this case, one out of 147 medicines, so they know one person will going to supply. So 1 crore 20 lakhs. So it is preventing all intended bidders to participate, my lord. I may supply 7 medicines, 20 medicines. And they are saying, no, you have to give 1 crore 20 lakh as EMD, and that must be rate-wise. The tender document must share the rate-wise, item-wise rate. So that EMD, that is as per the OJFR rule and General Financial Rule of 2017. My lord, that they are saying, if you will not disclose the rate of the item, that will be tender can be cancelled on that point only, because the public, those are going to participate in that tender, may not get at what EMD they have to pay. But I am going to supply 20 medicines as a distributor. I will participate in the tender. So what would be my EMD? Two minutes. My lord.
So
No supplier, my lord, as per the eligibility condition, no supplier, no bidder has that experience of supplying 4.5 crore in any 3 years of the financial year. In the counter, the malafide is there. What they have submitted in the counter, my lord, that requiring 3 years of experience supplying the veterinary medicine and vaccines and having a turnover of rupees 4.5 crore in any 3 financial year or 15 crore in a single year. So who have supplied without tender? Kamala and National, they have 15 crore supply in a 1 year. So this is not one of the eligibility condition in the tender. How can one who supplied 15 crore in a year will be eligible to participate? That is the care counter. So if your lordship I go by the definition or eligibility criteria, no one has that criteria because he has never been put to tender for last 5 years. But somebody without tender supplied, and for him, if somebody has supplied 15 crore, then he is eligible. So, my lord, and another point is that when this tender auction was not there, just last one, that my lord, all CDVOs, chief district veterinary officers, are allowed to procure medicines. And in that, we have all supplied the medicines for small amount. And the price comparison I have given, my lord, which molecule was 6 we have supplied in the district. That it is centrally procured from Kamala and National. I am not naming them, but for understanding, I am saying 40 rupees. 10 times more they are procuring centrally. And when district wise, we have given us 6 and 7 because there is a competition. There is a serious competition.
yes. That's all. Your 2 minutes is over.
My lord, yes, my lord. That's all. Well, last chance only, my lord. I'm not saying that any adjournment, my lord.
No, even not adjournment, even last year means.
My lord, rejoinder I have given. How the tender have been published by Orissa State Medical Board, OMFED, those are the corporation. They have stated every rate of every medicine instrument. These are the medicine to be supplied and the rate is this. So your lordship along with another rate is also pending. 1945.
That will take that will.
So both can be dismissed as 2 years.
Wait, accompli.
My lord, that I know, my lord, fate accompli. My lord, 1945, yes, that I know, but 2025, let it be annexed on Monday, the both can be dismissed.
Sorry about it.
So I can establish mother and son relation.
You finish this matter. I believe you are finished. Yes.
I hope your lordship, whatever, my lord, in the that's the elaborate order your lordship dictates. If that is there in that coordinate bench order, that what is the arbitrariness and what is that? That is.
Madam, we have to go with the judicial.
That ground has never been discussed.
Whatever. We will say that what has been discussed.
Only about the self-inherent power in my self-restraint.
We will say so.
And wrongly, all the judgments are applied in vacuum, not to the facts of the case.
Yes. Thank you. Is there anything you want to add, Mr. Advocate General?
But I don't think it has already been taken care of. Propriety limits that the coordinate bench has already
Don't
taken.
go by the observation of the bench. Sometimes it may be only.
Sometimes, my lord, we apply the wisdom not to be vocal. So she has submitted.
Why you have taken a plea that instead of 3 years, 15 crores in a year is also eligibility criteria? How can you impose more conditions which is not there in the tender?
I couldn't get your lordship, my lord.
She is reading a particular passage, which is the place, which is the paragraph of the counter.
Page 13 of the counter.
Page 13 of the counter, which you have filed.
Is
Eligibility, I think, in the middle portion after 20
riders of where it was specified bidder must have 3 years experience in supplying veterinary medicine and vaccines of its own manufacturing or reputed manufacturers of
No, we are not. I am just in the middle after 2019, 20, 2020, 21. After that, the eligibility criteria.
Eligibility criteria requiring 3 years of experience supplying the veterinary medicine and vaccines, having a turnover of 4.5 crore in any 3 financial years or 15 crores in a single year.
This is from where you got it.
No, it is not there, Miller. 15 crores is maybe it's
not there in 5.2.8.
No, it is not there.
So tell me, have you stated anywhere in your counter that they have submitted a 3 years financial experience with a turnover of 4.5 crores? Have you stated anywhere?
The petitioner.
No, you. In your
counter, state, Miller.
Yes.
It is not
stated. Have you stated that yes, this bidder, he confirms this particular clause having 4.5 crores turnover in last financial year, 3 years.
She says that she doesn't fulfill, therefore she is challenging.
Have you stated?
My lord, I am not getting your lordship. He is challenging that I do not fulfill this, so therefore it should be struck down.
Mr. Acharya, the question is very simple.
My lord.
We have to go by the pleadings which you have made.
Right.
In counter, have you specifically stated that the successful bidder has complied with the terms under
tender has not been opened so far, my lord. Tender has not been finalized so far.
Means?
Tender, my lord, there is an interim order. So therefore, the successful bidder is not before your lordship. It has not been opened.
No. I am just talking about that you have found certain bidders as successful or technically or financially qualified.
Technically, 3 bidders, my lord, have been found. Yes.
Have you insisted for 4.5 crores turnover in last 3 financial year
It is
or
there.
15
No, no,
crores in 1 financial
No,
year?
4.5 million. 4.5.
Yes.
Yes. That is in the tender term and condition.
Yes.
Page 4 million we have stated. Clause 5.255 document that the bidder average turnover of so and so for consecutive 3 financial year. Clause 5 to bid was specified. Bidder must have 3 years experience supplying veterinary medicines. Milord, it's a national bid. 25 bidders, Milord, participated in the pre-bid. All, Milord, international manufacturers or their authorized agents. And Milord, one thing is obnoxious. This particular petitioner, Milord, if your lordship would turn to page, she failed to, which page? Page 12. Milord, page 12 of the counter. Milord, even gauge, etc. Milord, only page 12. Milord, though in the past the petitioner was issued work order, by order dated so and so for supply of instrument, cabinet almirah, it miserably failed to honor the work order on account of its non-serious nature and financial instability. Similarly, in another occasion, work order has been issued to the petitioner by letter number 27/3/23 for supply of gauze cloth, roller bandage, etc. But the items supplied by the petitioner were failed in the quantity test and as such was not accepted by the technical committee. Accordingly, the petitioner was intimated and requested to take back the supplied items. All below standard items is supplying, and this is the specific allegation in page 12 of the counter affidavit. So it does not confirm the financial criteria, does not test the quality test, pass the quality test. Milord, page 12, serious allegation is there. And Milord, all branded companies have participated. Pfizer, all branded, Milord.
Yes, I got it. He has said that 3 years is the criteria.
3 years, Milord. 3 years is the criteria, Milord. That too, it is not only the particular.
Not. Yes, but it's not. Go
Milord, they will strictly go by the terms and conditions of the tender.
Thank you.
Yes.
Give it. I will dictate in the chamber. Otherwise, I will take near about 45 minutes to dictate.
Deeply obliged.
Yes, call the
Item number 13.
In this rate petition, in the interest of the public, my lord.
Yes.
21.
21, your lordship, is in absence of GST.
Item 22.
Please, your lordships. Lordships, the petitioner is a armed forces personnel. He is serving in Indian Army, and for him to apply for civil services examination conducted by UPSC and to claim the age relaxation. He has challenged the ex-serviceman re-employment in civil services rules, amendment rule 2012 under annexure 10, page 101.
Attorney General Service. Since the virus of this particular amendment, the statutory provision is challenged. So his Attorney General has to be served. Or you can receive the service or notice on his behalf. No difficulty, sir.
So can issue notice then?
What issue? No? You accept?
Yes. Yes.
Have you got this copy of the petition?
Yes, Your Lordship.
One copy then serve, another extra copy was confinement.
Give it. A physical.
My lord, I am appearing on behalf of the Union Publishers Commission. They have not supplied the copy. Let them supply the copy to the UPS, my lord.
Lordship, we have physically served it to the Union of India. We will serve another copy tomorrow.
They have not supplied, my lord.
Do you have any friend or a junior counterpart in the Cuttack upon whom he can serve?
Mr. P.R. Chatto is my associate.
Serve upon him.
Yes, sir.
When? Tomorrow?
Today itself.
Today. Matter to appear in the next Tuesday.
Yes, ma'am. Oblige.
Item 23.
Lots. Can I kindly fix a short?
Next Tuesday, what more?
That's
Short day.
Public.
Item 23.
Full under annexure 7 and 62. Orissa nursing education service, method of recruitment and condition of service to file to general college.
Notice on the advocate, learned advocate general, because you are challenging a particular provision of the Orissa nursing education service rules. The notice has to go.
All other
The writ petition is filed by the petitioner wrestling the Orissa nursing education service within method of recruitment and condition of service rules 2025 to be ultra virus. First of since the said rule is sought to be saved in the instance the learned advocate general is required to be noticed. Accordingly, the petitioner is directed to serve the copy of the writ petition upon the advocate general in course of this week. Matter to appear after 2 months.
Item 24.
Here I have a limited waiver. As we look only to annexure 1 at page 16. And here the order was passed for grant of quarry permit subject to deposit of a sum of rupees 27,24,000. Since the contracts were cancelled because of delay in passing the order. So after obtaining fresh contract, so I approached the appeal number 4 under annexure 5 at page 36 to allow me to deposit the amount which was assessed. No decision has been taken on annexure 5 by the appeal number 14 now.
This was assessed in 2021. Now you are permitting in 2025.
Since because all these quarry permits were granted in respect of a government works. Since there was delay in passing the order, so all those works were cancelled by the authorities concerned. So after getting the fresh contracts, I have requested the authority to allow me to deposit that amount. No decision has been taken. Either this way or that way they can take.
Representation. Yes, disposed of representation to be considered.
Within a stipulated period.
Annexure 4.
Yes.
Item 25.
Annexure 5.
The
5.
4 representation.
The core issue is that when a bidder withdrawing his bid, but the bid was evaluated on merit without allowing the withdrawal, can he penalize for the backout from the bid process? Here is the point portal was blocked that I was back out from the tender, but my bid was opened and evaluated on merit.
How can it be? If before the technical bid opening date, if they have said that don't consider my participation, withdraw, then how can you permit?
That I need to take instruction.
What need to take instruction?
Because they were aware of this specific.
What aware? He wanted to withdraw. Suppose if he is not technically qualified, then you reject his bid. That's all. But he wanted to withdraw, that I do not want to participate.
For the first time it is coming, that's why we.
The first.
And portal is blocked.
Portal is blocked.
That's the sort of.
What portal is blocked?
Online participated bidding 30th October it was blocked.
So we are
I think even my deliberation in the symposium has not
populated well.
has not been accepted in a very proper spirit.
Actually, there are some technical.
What technical? Nothing is, when the copy was served on you?
That actually we.
December.
Sir, we have held first blacklisting, then portal,
Yes.
isn't it? In a way,
Day after tomorrow. Can it be? The day after tomorrow.
Item 26.
They are blocking the portal. In a way, in a way, they are civil death.
Which one?
26. 26.
Yes.
My lord, the petitioner being a poor person has
Who is a
petitioner being a poor man, my lord.
engaged you?
I am, my lord, I can be engaged by a poor person. Yes, your lord, yes. Yes, my lord.
Yes.
My lord may consider my plight in this case. The petitioner seeks an extension.
What extension?
My lord, it is also covered by judgment of our own honorable.
What extension?
Extension of a sand query.
Name. Petitioner's name doesn't.
Oh.
That is 1 year, 4 months.
No, sorry.
What extension?
My lord, that is there. Our own honorable High Court in a similar situation has granted you.
I have not understood.
My lord, I am sorry. My lord, I am committed.
Minister wanted an extension of what?
Extension
Service
of
tenure.
extension of lease period. Lease fine. Extension of lease that has been granted to
What is
him.
the nature of the lease?
That is sand query,
Right.
my lord.
And he's a poor person.
Yes, your lordship. Except this, he has no source of earning.
Do you have another source of earning except this profession?
No.
But can't be regarded as a poor man. You are a very
This situation.
well-respected rich man.
He has got a genuine case, your lordship. So far, I believe, your lordship.
True. But start with the
Poor man, your lordship. I have verified. My lord, is a fact, in fact. I have verified. His condition is very deplorable. The condition is very, that is,
When you say we accept,
my lord.
keep it as a correct.
I also found that he is in a very poor condition. His condition is not good. What has happened, your lordship may consider. Here I have no fault. Now I have been selected as a successful bidder, and I have been granted the query to operate. Their own policy says lease should be executed. I have annexed it, sand policy. Lease should be executed by the Tahsildar concerned after obtaining all the consents and all formalities for seamless operation. So thereafter, this environmental clearance, consent to operate, now from other authorities, everything should be obtained prior hand. Now what has happened, your lordship? Once I got the consent to operate,